Now these are two different concepts. Let's look at the differences in it. The first basis is nature of contract. Sale is a current selling contract. That means it's a executed contract. Agreement to sale is it's a executory contract. Now we have studied under various types of contract, correct? In the last chapter, executed, executory contract. Similar to that, now here, sale means right now. Currently, I have sold goods to my customer. That is called as sale. Agreement to sale is I've just made an agreement right now to sell in the future. Got it? I've made an agreement right now to sell my goods in the future. That is called as agreement to sale. Second basis, transfer of ownership. Ownership of the goods is transferred at the time of contract. Under agreement to sale, ownership of the goods will be transferred in the future in certain circumstances. So as usual, right now if I'm selling the goods, the ownership automatically will transfer to the buyer. Ownership rights will be transferred to the buyer at the time of contract. Whereas agreement to sell is what? Because agreement to sale is happening in the future time period, the ownership rights also will be transferred in the future time period, not right now. Right now it's just agreeing to transfer, but I'm not transferring. Ownership right will be transferred only in the future. Third basis, transfer of risk. When goods are sold, the risk of the goods shifts to ownership of with ownership to buyer. Now, if there is any risk involved with the goods, it lies with the buyer now. Why? Because the buyer has the ownership rights upon the goods. Whereas agreement to sale, ownership lies with the seller. So the risk remains with the seller, not the buyer. Now, since agreement to sale, it is just agreeing now to sell in the future, the goods possession, ownership and any kind of risk associated with the goods will be remaining with the seller because the goods is yet to be transferred or the contract or the agreement is yet to be executed. It's still in executory stage. Therefore, the risk remains with the seller. 4. Right against each other. The seller may file a suit against the buyer for a price. Under agreement for sale, the buyer may file a suit against the seller for indemnity. Indemnity means just damages or charges. Now, under sale, seller has sold the goods to the buyer. Buyer has failed to make the payment. That is the price of the goods. In that case, yes, the seller can file a suit or file a case against the buyer for the price of goods in the court of law. Whereas in the agreement to sale, buyer may file a suit against only for indemnity. That means, let's say now A and B has agreed upon to sale or purchase of goods on a certain price on a certain date. Now, when that date has occurred, that is in the future, in case the seller is not selling the goods, maybe the seller says, I'm not going to fulfill my promise, which I have promised a month before that I will sell the goods to you, but right now I refuse to sell it to you. So basically, it is just agreement not being fulfilled. The promises not being fulfilled by the seller. For that, buyer can only sue him for only damages, not the complete price of the goods, just because he has backed out from the contract, just because he has not fulfilled his promises or obligations. I can only file a case for damages, but not the entire price of the goods. The last one, rights of the seller to resale. Now, when it is under sale, after payment of the goods in possession of the seller cannot be sold. Now, since sale is what? Right now it is executed. I have sold the goods to the buyer. Now, will the seller again can he resell it? No, because the goods complete rights and possession lies with whom? The buyer. So, whatever action has to be taken upon the goods, buyer can take up those rights, not the seller. Seller cannot resell. In terms of agreement to sale, the seller can sell the same goods again to another buyer. Now, in case, since it is executory, executory. Now we have looked at various ways where a contract can be breached, right? Just 2 classes before we had discussed how a breach of contract happens, either by alteration, either by remission, recession, etc. Now that can happen over here. Same goods, if in case say this buyer has told the seller, I don't want to buy the goods, so the contract becomes terminated, or uh, I mean to say the contract becomes cancelled in the eyes of law because the buyer has backed out. Now the same goods which he had promised to sell to the buyer A, now the seller can sell it to buyer B. So the seller has still the possession of the assets, possession of the goods, ownership rights over the goods. Therefore, seller can resell the same goods to another buyer. So these are the 5 differences between what is sale and what is agreement to sale. The basis were on the nature of contract, transfer of ownership, transfer of risk, right against each other, and right of seller to resale. Hope you've understood this concept. Next up we have conditions and warranty. Now every time you're purchasing a good, either it can be a washing machine, it can be a smartphone, or it can be a furniture, anything that you're purchasing, the manufacturer is always giving you certain conditions, correct? It has 2 years warranty, or the way it has to work, right? The basic necessary requirements of a particular product is called as conditions and warranty, right? How the let's say an air conditioner, how it has to work, right? It has to provide enough amount of cooling. That degree can be changed to higher cooling or lower cooling, etc. Now these are the basic conditions that is attached to the primary objective of selling of a good. So let's understand what is a condition according to the act. It is defined under section 12 subsection 2. A condition is a stipulation essential to main purpose of contract, breach of which gives rise to treat the contract repudiated. Now here, what is a condition? It is a stipulation. Stipulation means what? I've given the meaning there. Requirement. Stipulation means requirement. How should the AC function? It must be able to cool, correct? That is the basic requirement of the air conditioner. Next, essential to main purpose of the contract. That is the necessity of the necessity of the goods to be performed. For whatever purpose the goods is manufactured, that necessity it must be able to fulfill. Is that clear? If the air conditioner is not able to cool down or is not able to work for the purpose it has been manufactured, then the necessity is missing from the goods. Next, breach of which gives rise to treat the contract repudiated. What do you mean by breach? We already know this meaning very well. It means cancelling, or it means backing out. I'm breaking the promise, or I'm failing to fulfill my obligation in the contract. Is that clear? That is meaning breach. In case whatever condition you as a seller are giving to the buyer about the functioning of the asset or functioning of the good, if the very basic condition is failing, that is called as breach, then this can be treated as contract repudiated. Means what? Refusal or rejection. Okay, so I'm basically rejecting the product. I'm basically rejecting the goods that you have sold to me. Understood? What is the condition? What do you mean by stipulation, essential, breach, and repudiate? Is that clear? So if the basic function of the good is not able to being performed, then what is the point of buying the particular good or product? I better return it. Correct? The basic condition is not being fulfilled. For an example, A wants to purchase a car of mileage that gives 20 km per liter. So A is the buyer, B is the seller of car. So A is looking for a car which gives 20 kilometers per liter of petrol. Now B says yes, it does give 20 kilometers per liter. So A, after buying the car and using the car, he finds out that it only runs for 15 kilometers per liter. Now what was the basic condition here or stipulation? 20 kilometer per liter. That was the condition here. That was the main necessity or requirement of the car. That itself is not fulfilled, or that itself is not being able to perform by the car. Therefore, it is called as breach of condition. Main purpose of the contract is breached. Is that clear? Hope you have understood what is condition and the example. Next up, what is warranty? As per section 12 and subsection 3 of the Act, warranty is a stipulation to a main purpose of contract. That means it's just a collateral to the main purpose of contract, the breach of which gives rise to claim damages but not to reject the goods and that contract repudiated. Now here it is the basic or the essential of the goods, how it has to perform. Now let's say the color of the car has been changed. That is just a additional. If Mr. A was asking to I need a red color car only, but then B offered a blue color car, but the mileage is, yes, 20 kilometer per liter. Everything is fine. The main condition is good, but only the color has changed. So that is not the main, requirement or essential of the car. It is just additional. The color was just additional and the color was being changed from red to, let's say he has given a black car. Now that black car, the change of color here is called warranty. It is just a collateral to the main purpose of the contract. Just because he is given a black car, the buyer cannot cancel the contract itself. Maybe he can just claim what? Damages. Okay, just maybe a compensation for giving the wrong color car. Is that clear? So the breach of which gives rise to claim damages but not to reject the goods. Understood here? He can claim the damages but he does not have to reject the contract and that contract repudiated. Here warranty, you can only claim damages. You cannot reject the entire contract or goods. If warranty, if I've mentioned a particular color and it's not fulfilled, it's called as breach of warranty. Here if condition is not fulfilled, it is called as breach of condition. If warranty is not fulfilled, it is called as breach of warranty. Hope you understood the difference between. Let's look at the example. A buys horse which is said to be quiet to ride. The horse turns out to be noisy. Now here, yes, the purpose of horse is to ride. Yes, it is riding. The main condition is being fulfilled here. But then it's not quiet, right? It is making some kind of noise while riding. Okay. Now that is just a warranty. That is not the main purpose for what I bought the horse or for what A bought the horse, but it is just a collateral to the main purpose, that is condition. Condition was the horse must be able to ride. Warranty is it must be quiet, but it is making noise. That is what A found out. So the buyer's only remedy is to claim damages. So A can only claim damages for making noise, but he just cannot reject the horse or cannot cancel the contract here. So this is called breach of warranty because the stipulation made by the seller was only a collateral one. Is that clear? Hope you have understood what is condition, example, warranty and its example. Let's look at the differences between condition and warranty. What is the meaning of condition? It is a requirement or an event that should be performed before the completion of another action. Now, what is in simple words, what is condition? Requirement or the basic necessity for a good to be performed. Okay, for a product to effectively perform. What is warranty? It is an assurance given by the seller to the buyer about the state of the product, that the prescribed facts are genuine. So whatever you always find certain conditions on any product that you buy. Now you just believe that it has to be assurance. Yes, it is true. These are the conditions that is applying to the product. It is just a collateral to the main condition. Where is it defined? Condition is defined under section 12 subsection 2 and warranty is defined under section 12 and subsection 3. What is condition? It is directly associated with the objective of the contract. If the condition fails, the entire contract fails. But warranty, it is just a subsidiary provision. If the warranty fails, not necessarily the contract has to fail. It is a subsidiary provision related to the object of the contract. Does it result in breach? Condition? Yes. Breach of condition results in termination of contract. That means you're cancelling the entire contract. Under warranty, no, it does not result in termination, but yes, you can claim damages for the breach of warranty. Violation. Violation of condition can be regarded as violation of warranty. Violation of warranty does not affect the condition. Now, if the condition is being not fulfilled, that means even I'm going to it is equal that it is violating the warranty also. The main purpose only is not fulfilling. The additional collateral whatever you're providing, that also will be considered as breach. So I'm violating both. If I violate breach of condition, that is equal to violating the breach of warranty as well. But then in the case of warranty, it is not so. Warranty is violation of warranty does not affect the condition. As I just told the example, right? Buying the car. Yes, the main condition is good. 20 kilometers per liter, yes, the car is running. But then only the color of car has changed. So does not affect. Just because the color of car has changed, it does not affect the mileage of the car. You got my point? The color of car has changed. That does not result in the mileage of the car. That is called as warranty or the violation of warranty. What is the remedy available for the aggrieved party or for the buyer? If there is a breach of condition, yes, the buyer can repudiate the contract. That is, cancel the contract or terminate the contract. Whereas under warranty, he can only claim damages. He does not have to cancel the entire contract. Is that clear? The differences between condition and warranty. Under meaning, defined, what exactly is it? Result of breach, violation, and the remedy available for the aggrieved party. So, under which circumstances does condition can be treated as warranty? Now, few of the cases where the buyer once he has purchased the good and he has found some fault with it or the condition itself is not working, not every buyer would want to terminate the contract and return back the goods. There are certain buyers where they consider, I will keep the goods with myself. That means I don't want to terminate the contract basically, but you give me the damages, right? You have to pay the damages to me. So under which the first condition is buyer waives the condition of warranty. Now here he says that it is okay that I will keep the goods with myself. I don't want to terminate it. Even though the basic purpose of condition is not being fulfilled, I will not treat it as breach of condition, but I will treat it as breach of warranty. Now, if I treat it as breach of condition, I have to terminate the contract, correct? But if I treat it as breach of warranty, what do I do it? I can only claim damages. Therefore, buyer waives the condition of warranty. So, buyer he himself is considering, even though the main purpose of the condition of the contract is not being fulfilled, still I will consider it as warranty. Second, buyer treats the breach of condition as the breach of warranty. Now here make sure that the buyer is willingly claiming that even though the condition or even though the main performance of the contract, right, the main performance of the contract is not been able to fulfill, right? Now buyer is saying, instead of me returning back to the goods, right, and not taking the complete price amount of rupees, I will only claim the damages. So he can terminate the contract and he can reclaim the new fresh of goods. Okay, but then it is the buyer's choice that he treats it as a breach of condition, as a breach of warranty. Number 3, contract not separable buyer accepted the whole or part of goods. Now the third situation where the buyer treats condition as warranty is when the contract is not separable. For example, let's say buyer is constructing his home, and he has ordered from a company concrete, right? You need concrete to build a house or a building, anything, you need concrete. Now he has given the order and supplier is providing the full ready-made concrete with all the mix, right? You need the mixture of cement, sand and all the other things to make a strong concrete, correct? Those are the raw materials required. Now that is the buyer takes the order weekly from the supplier. So the first week, second week has gone by, he has already received it, and then the buyer finds out that the quality of the cement used in the concrete is very low quality. Okay, the quality of cement used in the concrete is very low quality. And now, can I separate the cement from the concrete now? Definitely not. I cannot separate it and give back the cement to him and again ask him to re-prepare the concrete. No, it is not separable. Contract is not separable. So because why? Part of the goods he has already accepted. Buyer has accepted a part of the goods already. Therefore, in this situation, the buyer decides the condition can be treated as warranty. He says, since it is inseparable, he cannot give back the entire concrete and say, I want to terminate the contract. Instead, for using the low quality cement, he can only claim damages. So all these three situations are taken up only by the buyer, or it is his choice to treat the condition as a warranty.